Thank you very much.
So, good morning, everybody. We all have gathered here today to start our SCAORA lecture series. Today, we have started with the first prominent lecture on the new criminal laws, which is very important and very in the moment on the vogue.
Thank you very much.
So we have today with us, we want to have we're honored to have Dr. Guruswamy ma'am today with us to start with the lecture series. She will discuss on the new criminal laws. We will start with Astha to give a brief introduction about ma'am. This lecture is being given live on the YouTube. So anybody who has questions can put the question on the chat box and the same will be taken at the end by ma'am. Over to you, Astha ji.
Thank you, Menakshi, and good afternoon, everyone. As Menakshi has already given an overview of what today's lecture holds for us, I won't take much of your time and quickly welcome our esteemed speaker for today, Dr. Menaka Guruswamy, Senior Advocate. Even though ma'am needs no introduction and has shattered many glass ceilings while being a familiar face in the Supreme Court corridors, her academic and professional journey definitely needs a quick mention here. Ma'am, having done her law degree from NLS Bangalore, went on to earn her master's in law BCL from Oxford University, where she was a Rhodes Scholar, and then a LLM from Harvard Law School before she secured a doctorate in law. Other than holding visiting academic positions at leading university, ma'am has been a Gruber Scholar and lecturer at the Yale Law School, visiting faculty at University of Toronto, and also has a distinction as the B.R. Ambedkar Research Scholar and lecturer at the Columbia Law School. After starting her law practice from the chambers of Mr. Ashok H. Desai, the then Attorney General for India, ma'am later also practiced law in New York. She has had a remarkable career so far and has been involved in a steady stream of complex criminal cases. Along with having a robust white-collar practice, ma'am also successfully appears and advises routinely on multiple cases involving money laundering, corruption, etc. From her representation of the main accused, the Air Chief Marshal in the Augusta Westland helicopters case, to representing the accused in the Delhi excise case currently underway, wherein she was instrumental in securing the first regular bail from the trial courts in the matter, to representing the accused in the 2G Spectrum case, and also being part of the Vijay Madanlal case, the litigation challenging PMLA, wherein her arguments have been elaborately recorded by the Supreme Court. Ma'am also acts as an Indian law expert in courts outside India, including most recently in Devas versus Air India case. That while the three new laws were being debated in the parliament before the Parliamentary Standing Committee, ma'am's exhaustive legal opinion on the key concerns and the implementation was placed on record by various members and which now forms part of the committee report. However, now that the laws are in force from the 1st of this month, ma'am, like everyone in the legal field, has endeavored to understand its nuances and implications in the criminal jurisprudence and is today with us to share her knowledge and expertise on the same, to help all of us as law practitioners to understand the technical and procedural changes and how to navigate through them. I'm confident that everyone joining in today will gain from this lecture. Welcome, ma'am. Over to you.
Thank you so much, Astha. And thank you very much to SCAORA for inviting me to deliver this lecture on new criminal laws. I'm going to now quickly change the view so I don't see a large black screen. And thank you all to all of you who have joined this lecture online on a lovely Saturday morning, sunny, and in Delhi. So I'm here to talk about the new criminal laws. And this is really a practitioner's lecture. This is a lecture by a practitioner of criminal law, and this is a lecture for practitioners of criminal law. So I will start by prefacing this lecture by saying there will be few jokes, but there will be lots of technical provisions that will be discussed in detail, because in many ways, when criminal law has changed in this dramatic fashion, we as practitioners have to have a grasp of the new law as is unfolding. So to begin, as many of you know, there's been a seismic shift in criminal law in India. The Bharatiya Nyaya Samhita 2023, or BNS, has replaced the Indian Penal Code 1860. The Bharatiya Saksha Adhiniyam has come in the stead of the Indian Evidence Act 1872. And the Bharatiya Nagrik Suraksha Sanhita 2023 is intended and replaces the Code of Criminal Procedure 1973. Let's start with the most essential. When do these three new laws come into effect? The three new statutes impact offenses that are committed on and after July 1st, 2024. So, for instance, an FIR filed on July 1st, the new regime of criminal law will come into place. The BNS, for instance, via a saving and repeal clause, specifically provides that it will not affect anything done or suffered under the Indian Penal Code 1860. So correspondingly, the new law that pertains to procedure and the new law that pertains to evidence will also come into place. Now, I like to structure my lectures, so let me do that by telling you that this lecture will be divided into three parts. Part one, we will focus on BNS 2023, which is the stand-in for the Indian Penal Code. So this is substantive criminal law. And so within this contours, we shall discuss what has not changed from IPC to BNS. Second, we shall consider the provisions very briefly that have been minimally revised. So small revisions, either additions or subtractions. And third, and most importantly, we shall interrogate what has been redefined in terms of existing general criminal law. And it is this last category on which we will pay most attention. In part two of this lecture, we will look at the Bharatiya Nagrik Suraksha Sanhita 2023 that replaces the Code of Criminal Procedure 1973. And the Code of Criminal Procedure 1973 is arguably my most favorite statute in all law, because I've always thought of the CRPC as the accused constitution, a constitution for the average accused who encounters the Indian legal system, the Indian criminal penal legal system. And in part three of this lecture, we will have a quick roundup on gains, losses of the reform effort, and I will take some questions if there is time, and if you're still holding on this fine Saturday morning. Now, before I go any further, I want to just show you the new statutes. Evidence Act is here now. So these are the three new statutes that have been passed and are now contemporary criminal law. I'd also appreciate it for those of you who have the statutes to keep those statutes nearby and ready, because it would provide easy reference to the provisions. And for those of you who don't have it, I will, of course, give you a sense of the new law and read out the statutory provision, and then we will interrogate it. Now, let's get started with the BNS 2023, which now replaces the Indian Penal Code. Within this, as I said, we'll first deal with minor changes, the cosmetic changes. By that, I mean substantive criminal law, where only the sections change. Then we'll go to the significant revisions before we go to the radical changes. Now, what are the kinds of section where there's just been cosmetic transformation? The Indian Penal Code, of course, comes into force in 1860. And experts suggest that substantially, well over 80% of the IPC is retained in the BNS 2023. So you have a substantial retention, right? What has been revised dramatically and on a large scale are the provision numbers, but the essences of the provisions have been maintained. This includes provisions that practitioners regularly engage: culpable homicide, murder, assault, forgery, criminal intimidation, defamation, and even mostly rape provisions. For instance, these cosmetic changes then look like murder, right, represented by classic sections 300, 302 of IPC, and now sections 101, 103 of the BNS. Of course, I feel a tinge of regret at this because, as practicing criminal lawyers, we would reel off the murder section. So you're having a hot cup of tea in court, a friend of yours comes and sits down and says, "Kya matter hai? Kiske liye ruke?" And you say, "Arey yaar, 302." Now we have to retweak that. But a majority of the change is a retweaking, cosmetic, the section numbers change. Now, the second part, and this is a smaller portion of what has changed, is that where there have been revisions, either additions or subtractions. Now, this is the second part of the BNS 2023 that I want to discuss. So, for instance, some significant revisions include that sedition, while it has been retained, and now sedition is, I believe, section 152 of the BNS 2023, the definition of it has been expanded, the nomenclature has changed, and the punishment for the offense has, at the far end, been made more extreme. One can now attract the offense of acts endangering sovereignty. So 152 of the BNS, acts endangering sovereignty by exciting secession or armed rebellion or subversive activities or encouraging feeling of separatist activities or endangering sovereignty. Under the new BNS, the punishment is now 7 years to life. So the definition of what constitutes this kind of understanding of what we would consider treason or acts endangering sovereignty, that definition has been substantially expanded. And the imprisonment, the punishment, 7 to life, has also been increased in contrast to the IPC. What's another example? The BNS 2023 now, very categorically, under section 106 of the BNS, specifically punishes death caused by negligence of a registered practitioner while performing a medical procedure with imprisonment that may extend to up to 2 years. And this is section 106 of the BNS. Now, it's not like under the old regime, under the IPC, doctors, registered medical practitioners could not have been proceeded against, using principles of 304A, etc. But now the legislative intent is clear. It is mentioned in an explicit fashion that the registered medical practitioner can be punished for death caused by negligence while performing a medical procedure. So this is the legislative intent has now changed, and the statute in play for when a registered medical practitioner may be accused of negligence and thereby causing death is now explicitly mentioned in the statutory provision, which is now section 106 of the BNS. Now, there is also welcome reforms in all of this context, which includes, and by welcome, I mean that reforms that move beyond a traditional understanding of what is punishment, imprisonment, fine, so on and so forth, to also community service. Now, section 303 of the BNS, for instance, in cases of low value theft, and if you encounter the criminal justice system, you will know that most under trials and many offenders are in the system or are encountering the system or are accused for low value crime. So 303 of the BNS, and this is a wonderful reform, says that if you are an offender who has been convicted for the first time, where the value of the stolen property is under 5,000 rupees, then given that this is really petty theft, you can in fact perform community service. And community service is a specific addition as a reformatory punishment that offenders may be made liable under section 4F of the BNS 2023. So this is a specific mention This is one of the kinds of punishment, and I call it a reformatory punishment that offenders may be subject to. These are first-time offenders. This is an example. A petty theft, valuation under 5,000 rupees. I think this is a very welcome step. I think it will go a long way in young people who encounter and are being processed by the criminal justice system, and instead of being in fact subject to imprisonment, you formally will be entitled to petition for community service. Now, this is the second part of substantive criminal law, which has changed. Now, the third part that I want to discuss are dramatic changes that have been brought into substantive criminal law, and that is the BNS 2023, which seems to be at odds or somewhat rather different from the established principles of criminal law as do exist in India. Now, the most dramatic changes to substantive criminal law, and I will come to procedural criminal law in the second section of this lecture, but the most dramatic change to substantive criminal law, in my opinion, is the incorporation by legislative intent, by the new statutes, of moving into general criminal law. So the BNS, moving into general criminal law, what otherwise pre-July 1st, 2024, were considered special laws or harsh laws. And by that, I mean, for instance, let me illustrate this. Special laws or harsh laws are, for instance, the Unlawful Activities Prevention Act, or UAPA, as practitioners call it, Maharashtra Control of Organized Crime, 1999, or MACOCA, as we call it. So these are special laws. They're harsh in how they process offenders, and the punishments that are meted out for what are considered very serious crimes, and therefore you have a special statutory framework. You may have a special court system, you may have special safeguards, and that was erstwhile in special statutes. Those have now been transposed into substantive criminal law, that is the BNS 2023. So traditionally, till 2024, July 1st, special laws were a distinct body. And general criminal law, IPC, was a distinct body of principles. Now, what the BNS 2023, and subsequently you'll see the new procedural laws bring in, is they bring these special laws into general criminal principles. Now, first, I have to say that I want to give you a very quick overview of what makes these special laws so special, right? Unlawful Activities Prevention Act 1967, UAPA, and MACOCA 1999. Both statutes are illustrations of special legislation that are intended to combat offenses, alleged offenses, that are elaborate in how they are planned and how they are fulfilled. So the planning and the fulfillment requires an elaborate pattern of conduct and intention. So while the punishments are harsh, special laws have procedural safeguards that attempt to balance the rights of the prosecution, the interests of the prosecution, and the rights of the accused. So there is a balance that the special laws at least attempt. The BNS brings these special laws, for instance, UAPA, for instance, MACOCA, organized crime, into the framework of general criminal law. So, for instance, there is a definition of organized crime, which otherwise we draw both in, not just in Maharashtra and Delhi, but there are variations of MACOCA all over the country. So organized crime till July 1st, 2024, drew from MACOCA. Today, BNS 23, section 111, includes within the definition of organized crime, unlawful activities, including kidnapping, robbery, vehicle theft, land grabbing, contract killing, trafficking of human beings, weapons, drugs, smuggling, trafficking by two or more persons, acting singly or jointly. And the punishments range from 5 to life or death, and depending on if it's petty or if it's not petty. So petty organized crime like theft, snatching, pickpocketing, shoplifting, cheating shall be punishable from 1 to 7 years. Now, BNS brings that organized crime into the framework of general criminal law by virtue of placing it in a statute which speaks to general criminal law. Now, before I expand on how BNS deals with organized crime, let me give you a quick flavor of MACOCA as a special statute to illustrate this point for those of you who don't engage MACOCA and organized crime on a routine basis in criminal practice. So MACOCA protections, special law and general law. MACOCA today, and since it came into play, has procedural safeguards that prevent abuse of such special law with stringent and deterrent provisions as per its own statement of objects. For instance, existing MACOCA section 23 presently provides that no information about the commission of an offense of organized crime shall be recorded by a police officer without the prior approval of an officer below the rank of ACP, Assistant Commissioner of Police. Further, no investigation shall be carried out by a police officer below that rank. No special court, and there are special courts for MACOCA, shall take cognizance of any offense under this act without the sanction of a police officer of the rank of ACP and above. MACOCA has special courts that are staffed by judges specially appointed by the government with the concurrence of the Chief Justice of the Delhi High Court. Such a judge should have had, this is important, experience as an assistant sessions or sessions court judge previously. Importantly, authorization for interception of wire, electronic, or oral communication shall only be allowed after an officer not below the rank of DCP, who is supervising the investigation, submits an application to the competent authority. And a review committee consisting of the Principal Secretary of Delhi, Law Secretary, Home Secretary shall review the orders of the competent authority. In a sense, MACOCA, so my point is an example of a special statute intended to combat an elaborate offense, organized crime. It balances the stringency of not just the punishment it mandates, but also the invasion of privacy by wiretaps, etc., to further enhance the investigation along with procedural safeguards. Care was taken by the legislature in the constitution of special courts, the qualifications in terms of prior experiences of the judges who will hear such cases. All of this is now somewhat different or absent in general, the new general criminal law, which has been brought into force in terms of the BNS 2023. Similarly, UAPA offenses are brought under section 113 of what is known as the Terrorist Act under the existing new BNS. The UAPA's definition of who commits a terrorist act has been replicated in BNS 2023. A terrorist act in UAPA and in BNS is defined as whoever does any act with the intent to threaten or likely to threaten the unity, integrity of India by using an array of weapons like bombs, chemicals, etc., amongst others. If death results from such terrorist act, then the punishment could be life, imprisonment, or death, and in other cases may range from 5 years to life. Now, while the definitional provisions of UAPA and BNS 2023 are similar, the difference is that the UAPA has comparatively, the special statute, the UAPA, had comparatively greater procedural safeguards. The BNS 2023, while it provides that an officer of the rank of SP, at least, shall decide whether to register the case under the BNS or the UAPA. But more specifically, let us now look at, if I've provided a brief but overview of what is a special statute under existing criminal law prior to July 1st. Now let us look at what the Bharatiya Nyaya Sanhita, the BNS 23, which is substantive criminal law today, what it provides for in the context of erstwhile special laws. Now, the BNS through sections 111, and for those of you who have the statute, please look at section 111, which speaks to organized crime. I'm going to quickly read it out because I'm assuming that many of you won't have the statutes. And it says this: any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offenses, cyber crimes, trafficking of persons, drugs, weapons, illicit goods or services, human trafficking for prostitution or ransom by any person or group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. And what is organized crime? As the explanation to section 111 provides, organized crime means a group of two or more persons, so two or more, who acting either singly or jointly as a syndicate or gang indulge in any continuing unlawful activity. A continuing unlawful activity means an activity prohibited by law, which is a cognizable offense punishable with imprisonment of 3 or more years, undertaken by a person either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheet has been filed before a competent court within the preceding period of 10 years. And that court has taken cognizance of such offense and includes an economic offense. Now, economic offenses, there's a further definition of that as including criminal breach of trust, forgery, counterfeiting of currency notes, banknotes, government stamps, hawala transactions, mass marketing. Whoever commits such organized crime shall, and this is the punishment conceptions and provisions, shall, if such offense has resulted in the death of any person, be punished with death or imprisonment for life, and also liable to fine, which shall not be less than 10 lakh rupees. So if the offense results in death, the punishment could range from life to death. But in any other offense, which doesn't result in death, could be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and with a fine of 5 lakhs. Now, importantly, whoever abets, attempts, conspires, or knowingly facilitates the commission of an organized crime or otherwise engages in any act preparatory to an organized crime shall be punished with imprisonment for a term which shall not be less than 5 years, but which shall extend to imprisonment for life. So this provision of amendment, attempting, or any person who is a member of a syndicate will attract provisions of 5 years imprisonment to life. Importantly, whoever intentionally harbors or conceals any person who has committed the offense of an organized crime shall be punished with an imprisonment for a term which shall not be less than 3 years, but which may extend to imprisonment for life. So here you will see that not only does the definitional clauses of BNS in the context of organized crime not only expand these definitions of what is organized crime, but it in fact brings into play harsher punishments of what is organized crime. It extends this to anything that is perpetuated by 2 or more persons. So yesterday, I was arguing a case in the Supreme Court, which was perhaps at best an elaborate theft involving pension funds by accountants, and those pension funds had been siphoned off and also put into the bank accounts of many, many, many family members. Now, that is being tried under pre-existing and to this extent existing Indian Penal Code provisions. So at best, the family members are looking at theft, receipt of theft, goods that are a receipt of theft, and those punishments then speak to 3 years and so on and so forth. Today, if that same offense were committed post July 1st, then they would in fact be processed as syndicate members of organized crime. And those punishments would then vary, would start from 5 to life. So the defense then that we would have to build would be under these provisions and would be in response to these existing provisions of the new BNS. Now, some will believe, some practitioners will think that this is a good addition to existing criminal law to bring in organized crime into general criminal law. And other practitioners will believe that this, in fact, renders it harder and harsher for an accused, including accused who are, family members, to, in fact, prove their innocence and will, in fact, be processed more stringently in the context of the criminal justice system. Now, irrespective of what, as practitioners, we feel about stringent punishments and less stringent punishments, my job today as a lecturer is to really speak to the idea of what is the change in general criminal law. The change in general criminal law is that the BNS 2023 imports from special statutes like Menaka, and we will also move on to UAPA, which is now considered and defined as a terrorist act. So imports from these special statutes, which have, by virtue of being special statutes, Menaka, UAPA, etc., also have special courts, special procedural demands that are placed on the prosecution, that are placed on the police, that are placed on the investigators, and that are placed on the prosecution and that are utilized by defense. Those are in turn absorbed into general criminal law, and that has consequences for the accused and for the way the defense bar will react in building a defense. Let's now look at section 113 of the BNS, which speaks to terrorist acts. Right? So this is a definitional provision, and this really draws from special law like the UAPA. So what is a terrorist act? Whoever, and I'm just going to read the statutory provision, assuming that many of you will not have the statute. Whoever does any act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, economic security of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country by using bombs, dynamite, so this is subclause A, by using bombs, dynamite, or other explosive substance or inflammable substance or firearms or other lethal weapons or poisonous or noxious gases or other chemicals by any other substance, whether biological, radioactive, nuclear, or otherwise, of a hazardous nature and is like what is likely to cause or causes 1, death of or injury to any person or persons, 2, loss of or damage to, destruction of property or disruption of any supplies or services essential to the life of the community in India or in any foreign country, or damage to the monetary stability of India by way of production or smuggling or circulation of counterfeit Indian paper currency, coin, or other material, damage of any property, and overawes by means of criminal force or the show of criminal force or attempts to do so. All of this will constitute, quote unquote, a terrorist act under section 113. Now, whoever commits such a terrorist act shall, again, if such offense has resulted in the death of any person, be punished with death or imprisonment for life and liable to fine. And in any other case which has not resulted in the death of a person, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall be also liable for a fine. Now, whoever conspires or attempts to commit or advocates, abets, advises, or incites directly or knowingly and facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act, and this is very important, or any act preparatory to the commission of a terrorist act shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life. Now, there are various provisions under 113, which speaks to organizing, imparting training, camps, membership of an organization, and voluntarily harboring, concealing, or attempting to harbor or conceal. Really wide definitional provision. And the explanation provides that an officer not below the rank of SP, Superintendent of Police, shall decide whether to register the case under this section of the BNS or under the Unlawful Activities Prevention Act 1967. Now, before I move on to the second part of this lecture, which speaks to procedural laws, I want to end this first section by saying simply this. We have three kinds of changes that have been brought into substantive general criminal law, the BNS. One, just the section numbers have changed. It's a large percentage of the statute, which is, of course, a relief for practitioners like myself. We don't have to remember many new provisions. Two, we've had some revisions, addition or subtraction. For instance, now the statute specifically provides for a registered medical practitioner. The statute, for instance, changes, expands the definition of sedition and terms it as something else, but speaks to what used to erstwhile be sedition. And the third change, the more dramatic change, the absorption of special statutes, special crime, as we call it, because of its elaborate nature, UAPA type offenses, organized crime, Makoka type offenses, into general criminal law, calling it organized crime, calling it terrorists' activities, into general criminal law, which then speaks to the next set of challenges which shall arise, which will speak to, will there be procedural safeguards that are otherwise provided for in these particularly special but harsh existing legislation? Will you have special courts, or will those be transport? Or will generally the criminal courts now take into play what is organized crime and what is terrorism? So that I will leave there. And I have no doubt that there will be much debate, much writing, and maybe even court challenges, which will speak to this. Now, the second section of this lecture, and I'm acutely aware that now I have spoken for, I think, almost a half an hour. So I will now try to be briefer and more brisker. The second section speaks to the Bharatiya Nagarik Suraksha Sanhita 2023. I'm going to say that again. The Bharatiya Nagarik Suraksha Sanhita 2023, or the BNSS 2023, that replaces the Code of Criminal Procedure 1973 for offenses pertaining to after July 1st, 2024. So while substantive criminal law is BNS 2023, procedural law I will refer to as BNSS 2023. Now, in this lecture, I do not have the time to go through all the new provisions of procedural law. I will stick to two very important procedural changes that have come into place. I say important and I highlight them because these are two sections which implicate practitioners greatly, because we often have to navigate these sections as it pertains to our clients or our instructing lawyers' clients. Now, these two provisions that I will deal with in some detail speak to custody, the custody that the state can ask for and secure under procedural law and changes to new procedural law. And the second section that I will deal with is those pertaining to preliminary inquiry or the registration of an FIR, the mandatory registration of an FIR, which the Supreme Court spoke to in Lalita Kumari. So I'm going to deal with these two provisions because these are provisions that us practitioners commonly encounter or engage. Now, first, I want to deal with the general procedural provision that exists prior to offences committed post July 1st, 2024. Now, Section 167 of the Code of Criminal Procedure as it exists authorizes custody, and this is quite important, the technical language, authorizes custody up to a maximum of 60 or 90 days, depending on the extent of punishment prescribed. Further, it contains a proviso, this is Section 167, which seems to limit police custody up to 15 days. So I'm going to first read existing Section 167 CRPC, and then I'm going to take you to the corresponding provision, which is Section 187. And I'll request you to make a note of this, of the BNSS, the Bharatiya Nagrik Suraksha Sanhita 2023. And arguably, the BNSS 2023, while similarly enabling detention in custody for 60 to 90 days, seems to do away with the 15-day limit for police custody. Let us interrogate both the provisions, and this is very important because this really is about statutory reading, the reading of procedural criminal law. So it is technical, bear with me, we will read through it. First, the existing law, and then I will take you to Section 187 of the BNSS. Section 167 of CRPC authorizes custody up to a maximum of 60 to 90 days, depending on the extent of punishment. It says, the proviso reads, 167, existing CRPC, the magistrate may authorize the detention of the accused person, and please make a note of this, otherwise than in the custody of the police, beyond the period of 15 days, if he is satisfied that adequate grounds exist for doing so. But no magistrate shall authorize the detention of the accused person in custody under this paragraph for a total period exceeding 90 days, where the investigation relates to an offense punishable with death, imprisonment of life, or imprisonment for a term not less than 10 years, and 60 days where the investigation relates to any other offense, and on the expiry of the said period of 90 or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail, and every person released on bail under this subsection shall be deemed to be released under the provisions of Chapter 23. Now, the most important proviso language of the existing Section 167 of CRPC. I'm just going to read those two lines again. Please make a note of this. And then we will go to the corresponding provision under BNSS. The magistrate, the proviso, the magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days. Otherwise than in the custody of the police beyond the period of 15 days, if he is satisfied that adequate grounds. Now, let me take a sip of water and then go through now the new Section 187 of the BNSS. Now, 187 of the BNSS retains the timelines of 60 and 90 days, concept of default bail as in CRPC. However, what does it seem to omit? Arguably, it omits the maximum limit of 15 days. What we read there, otherwise than in police custody. Let's read the relevant parts of Section 187. Please make a note of this. Section 187(3) of BNSS 2023. 3. The magistrate may authorize the detention of the accused person beyond the period of 15 days, if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding 90 days, where the imprisonment relates to an offense punishable with death, imprisonment for life, etc., or 60 days where the investigation relates to any other offense. So what is omitted? Otherwise, the section is transposed from the old to the new. What is omitted are the 7 words, otherwise than in the custody of the police. Otherwise than in the custody of the police. So this then means that when we analyze the section, we have to navigate the fact that, does this mean that police custody can be greater than 15 days? What are the consequences of that? For those of us who practice criminal law, the idea that an accused will spend more than 15 days in police custody means that there will be a great impact on both the mental health of the accused, the ability of the police to influence the accused. But be that as it may, let us now contrast, let us assume that police custody can be greater than 15 days. What does even special harsh provisions of special statutes like UAPA, Unlawful Activities Prevention Act 1967, say in the context of custody of the police? Section 43D, because when you want to evaluate what police custody means, the evaluation cannot just be good and bad. The evaluation has to be mild, harsh, excessive. As practitioners, we have to navigate punishments, especially custody. And custody is, in fact, a grave burden on Article 21 rights of the accused in the context of what is considered otherwise existing law, what is considered custody that the accused must be subject to, and what even harsh statutes like UAPA term custody in the context of, yes, UAPA is more excessive than erstwhile existing criminal law. Now, please see Section 43D of Unlawful Activities Prevention Act 1967. UAPA prescribes up to 30 days in police custody. Section 43D is modifies the application of Section 167 of the CRPC and changes the 15 days to 30 days. Further, 43D of UAPA states that the investigating officer is required to file an affidavit providing reasons for seeking police custody if the accused is in judicial custody. Now, Section 187 of new procedural law, the BNSS 2023, seems to impact safeguards against what potentially might be police excesses and what potentially might be an under trial's rights that are well recognized from cases like DK Basu 1997 onwards under Article 21 of the Constitution of India. And DK Basu, of course, is our classic case, DK Basu versus the State of Bengal, 1997, 1 SCC 416, where DK Basu speaks to custody, Article 21 rights of convicts, under trials, detainees, and other prisoners in custody. And any other form of torture, cruel or inhuman treatment would fall under the inhibition of Article 21 rights. Now, the issue, of course, with police custody, and I don't have to tell practitioners, of course, is where a person accused of an offense is maximally vulnerable in the context of confessions, forced confessions, signing of blank papers, so on and so forth. Practitioners of criminal law are well aware of this. Now, mindful of the time, I'm going to very quickly now go to BNSS and its issues in the context of the registration of FIRs and the age-old practice of preliminary inquiries that seem to exist erstwhile, especially prior to Lalita Kumari. Now, I'm going to first take you very quickly, and I'm mindful of time, so I'm going to run through this section. I'm going to take you to section 154 of existing CRPC as it deals with registration of FIR. I will then take you to the position pre-2014 and then very quickly to the Supreme Court's position in Lalita Kumari, which makes the registration of FIRs mandatory, ending with the relevant provisions of BNSS, that is section 173 of the BNSS. Now, 152 of existing CRPC basically deals with the registration of an FIR. 154.1 says, every information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, be read over to the informant, and every such information, whether given in writing or reduced to writing, shall be signed by the person giving it. Classic FIR until 2014, which is the decision of the Supreme Court. Until 2014, police officers had the discretion or exercised the discretion in the context of lodging an FIR, whether the FIR was to be lodged or not. Many Indians who have the experience of running from pillar to post trying to lodge this FIR. Alternatively, of course, the complainant had the option of 156.3 of the CRPC. Be that as it may, the Supreme Court brings to an end this unfettered discretion of the police with a constitutional bench decision. This is one of the classic cases of the Supreme Court of Indian law and a great reform, great post-colonial reform brought out by the Supreme Court in this classic case of Lalita Kumari versus the government of UP, 2014, 2 SCC, page 1, 5 judges of the Supreme Court in a constitution bench hold that the registration of an FIR is mandatory if the information given to the police disclosed the commission of a cognizable offense, speaking to section 154 of the CRPC. Further, the court provides a very narrow category of cases where a preliminary inquiry may be required. This is in the context of matrimonial disputes, commercial offenses, medical negligence cases, corruption cases, so on and so forth. Limits the Lalita Kumari court limits the scope of this preliminary inquiry. Now, the BNSS in section 173 of the BNSS 2023 seems to revert to the pre-Lalita Kumari position. I'm going to now read section 173.3 of BNSS, and this is something I will request you to mark, section 173. Without prejudice to the provisions contained in this section on receipt of information relating to the commission of any cognizable offense which is made punishable for 3 years or more, but less than 7 years, so 3 to 7 years, the officer in charge of the police station may, with prior permission from an officer not below the rank of DSP, considering the nature and gravity of the offense, so 3 to 7 years, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days and proceed with an investigation when there exists a prima facie case. So 3 to 7 years. So there seemingly are twin conditions attached to 173.3 of BNSS. 1, prior permission from the DSP, and 2, preliminary inquiry could be conducted on whether a prima facie case is made out or not. Now, as my colleague in my chambers, Utkarsh Pratap brought to my notice in a very heated conversation, 98 offenses in the BNSS have punishments ranging, from 3 to 7 years. Thereby conferring on the investigating officer unfettered discretion to ascertain whether there is a prima facie case that would merit registration of an FIR. These offenses include theft, cheating, criminal breach of trust, dishonestly receiving stolen property, counterfeiting a property mark. This is really a majority of white-collar crime. It is the first time that codified law has conferred such powers on the police. And given Lalita Kumari, it is interesting to see how this specific provision of the BNSS 2023 will hold up in the face of Lalita Kumari. Now, it's not like there is not much revolutionary and welcome reform into existing criminal procedures. Some of it draws, the BNSS draws, and I'm going to end with this section. Some of it draws on technological innovations that have made it into our everyday life. For instance, now the entire life of a new case, commencing from the FIR, leading to a case diary on its way to a charge sheet, culminating in a judgment, is to be maintained online via digitized record keeping. This will, of course, make it immeasurably safer in the context of the record of criminal proceedings. When our homes are searched and seizure affected on items, and proceedings must be accompanied by mandatory video recordings. BNSS 2023 also provides for the registration of a zero FIR, where this is an FIR where a police station receives a complaint regarding an alleged offense committed in the jurisdiction of another police station. This is 173 BNSS. BNSS 2023 also makes it mandatory for a forensic expert to visit the crime scene, collect forensic evidence for information relating to an offense that is punishable by imprisonment for at least 7 years. This is 176.3 of BNSS, and recording of evidence can be conducted by electronic or online mode, 530 BNSS. Right? So there are pros and cons to this recording of electronic evidence. And of course, reform also in the context of sanction must be provided by the state in the context of a government servant. This is section 218 of BNSS, within 120 days of receiving the request for sanction. So there is much welcome, much in the context of technological changes that our day-to-day lives have absorbed, that also procedural law seems to absorb in the context of investigation, the maintenance of the case record. But in the context of the registration of an FIR, the discretion that is provided, the context of custody, the missing omission language of other than in police custody, the removal apparently of the 15-day marker, these are in fact new changes to procedural law that have been brought in by the BNSS that merits some thought. So it's about 12:55 now, and Astha and SCAORA, I think I will stop my lecture here. I have many more things to say, but I will open this up for a couple of questions and any comments that any of you may have, and also have a sip of water.
After ma'am takes a sip of water, I would thank you, ma'am, for a wonderful and extensive lecture here.
Thank you very much.
I will start taking questions first, and then Pragya ji will give a vote of thanks to ma'am.
Thank you.
The first question that has been asked by Mr. Hemant is that, ma'am, I filed a case under section 156(3) CRPC on 1st of July. The difficulty is that the judge posed a question as to which law and procedure will be applied in the present case. If you can please share a valid.
Shall we just take a couple of questions, Chair, just 2, 3, and then I'll just answer it all in one lot, since we're just a few questions and we're running out of time.
Right. Also, ma'am, there's another question asked is that as community service is being one of the punishments, how do we see it as being misused, in this time, especially with the recent case of the Pune Porsche case? So how do you think it will be there? Another very important question which has been quoted is, ma'am, just a minute. Also, ma'am, there's another very important question that the remainder of section 377 in the form of sodomy and bestiality existed in the IPC even after striking down of section 377. What practical issues can we face after complete removal of these penal provisions? So, ma'am, answer these 3 questions.
Thank you. So essentially, the first important, and many courts, I've been in court where, judges have asked this question, which law do we apply? And there are, in fact, 1 or 2 orders of courts, which I'll share with SCAORA and with Vipin, which might be useful to your membership, which speak to essentially when these statutes kick in. And it is really when the offense was committed. July 1st, 2024, because there are saving and repeal clauses in each of these new statutes. So, for instance, in BNS, the saving and repeal clause very specifically says it will not affect anything done or suffered under IPC. Conception being, when was the offense? When is the offense? Right? And there are two very short orders which I'll share with you online. You can circulate them. These orders are obviously not detailed judgments right now, but they speak to this idea of what kicks in and when. Right. So that's the first thing. I have to say, a second question was sent directly to me, and I must apologize because some of your members have my numbers. Vipin is smiling here. And they said, ma'am, please answer this. How has section 34, 147 and 120 of the old act been dealt with in BNS? I'm going to apologize. I have to answer this because I have received this question from a member of yours who is a dear friend of mine who's taught me much criminal law, I should say. Erstwhile 120A and B IPC now find mention, my friend, in section 61 of the BNS. Right? The provisions are mostly unchanged, except that the words with the common object have been added to the provision. This is very, very important because this, for all of us who practice criminal law, 34 common intention is very, very important in the context of criminal practice. And 149 IPC, someone just sent me another question. Your members are very direct and forward, received in WhatsApp. Provision 149 IPC, unlawful assembly with common object. I just argued a case on this yesterday in Supreme Court, is now under 190 BNS. Right. The language employed is exactly the same. This is a big relief because 149 is bought in enormously. Enormously. So much of criminal law has 149 defense that you have to make. So that is now brought, is almost identical in 190 BNS. Now on 377, being removed, there is an issue because what happens when in the context of the rape of a man? This is a void. And this exists now. This void exists because this can also, in fact, this is a void. There is no other way of, in fact, saying this. I have no other way of saying it. And my juniors who are very worried as I give this lecture have said to me, please repeat again. So I'm going to repeat. Date of occurrence of the crime, IPC, CRPC, anything, date of registration of the crime is the most important date. Prior to 1st July 2024, anything after 1st July 2024, procedural law to be followed, BNSS. The substantive law to be followed, date of registration on or after 1st July 2024, substantive law, BNS, BNSS. Right? So the date, this date is what is most crucial. So I will stop here. And pleased for your members, any other questions, you can just contact me directly on WhatsApp. I want to say that, I started practice when I was quite young, 21, Vipin. And so much of my practice was, in the CBI courts and the trial courts. And the heart of my practice is criminal law. So, for us also as practitioners now with over 25 years, these changes, we are also learning new substantive law. We are also learning new substantive law. And the lesson really is that as lawyers, we keep having to be ready to absorb new law. And this reform effort also reminds us that we have to be able to absorb new law, understand its strengths, understand its weaknesses, and do what we do, defend the accused. Right? So thank you so much. I want to thank you guys for having me. I've really enjoyed this. I love being able to lecture on criminal law.
I would now request Pragya ji to kindly give a vote of thanks to ma'am.
Thank you, Menakshi ji. Honorable Senior Advocate Dr. Menaka Guruswamy, ma'am, esteemed members of SCORA Executive Committee, distinguished guests and colleagues, on behalf of SCORA Executive Committee and everyone present here on this Saturday afternoon, I extend our heartfelt gratitude to Menaka ma'am for gracing us with an enlightening lecture on the intricacies and nitty-gritties of the new criminal laws. Your profound insights and comprehensive analysis have undoubtedly enriched our understanding of these crucial developments. Your dedication to the legal profession and your willingness to share your expertise with us are truly commendable, ma'am. The clarity with which you've elucidated complex legal principles and the practical implications of these new laws have left an indelible mark on all of us. We look forward to your continued guidance and support in our endeavors. Thank you so very much, ma'am. It was a great
Thank
learning.
you so much. Thank you so
Thank
much
you.
for having me. Thank you. Huh?
Doctor, before we close, I think
Yes.
we were just discussing in our committee. I don't think there's anybody who's done this kind of academic excellence that you have.
Thank you. I'm
I
grateful.
should repeat it again that you not only are from NLS, you've done it from Oxford, you've gone to Harvard, you've been teaching at Yale and Columbia. There's nothing left. So
Yes.
we are very fortunate for this lecture.
I'm very grateful, Vipin. And I just want to say that, you know, my maximum teaching, Vipin, has come from colleagues at the bar and judges on the court. Really, you know, from being a young lawyer, from my senior, but it's my colleagues and judges who have always, you know, helped me along. And this is something as a guild profession, Vipin, and we are a guild. We learn from each other, you know, younger and older members like myself. And now, you know, one is in the older section of the bar. We learn from our colleagues and we learn from younger members. So I'm grateful. The biggest teaching for me has been the court system in India. And I'm always grateful to my colleagues and the court system for giving me, I'm a first generation lawyer, I'm a woman, many, many things, you know, for giving me the chance to have a big, robust practice of law. So thank you. I'm grateful.
Thank you so much.
Thank you.
Thank
Thank you so much.
you.